Welcome kapatid to our series on how to answer law school and bar problems. Today we are taking a look at a problem from the 2022 bar exam. I'll be showing you precisely how to answer a problem, how to be responsive to a problem, and how you can also arrive at an elegant and precise answer all on your own. All of this and more coming right up. Hi, my name is Lex and welcome to Lex in Motion. In this channel, I'll be helping you build your competence, confidence, and capability in law school. Start today by hitting the subscribe button below. New episodes are posted every Friday. Without further ado, let us now begin with the problem from the 2022 bar examination. I'll be showing it on your screen right now. The first step in answering every problem is to take a deep breath. Find a way to calm yourself down. Don't look at the problem, don't look at your screen. Ipikit mo ang iyong mga mata kapatid at huminga ka lang muna ng malalim. The second step is to take another deep breath. As you exhale, know and understand that however way you're going to answer this next problem really is not going to matter. Tuldok lang ito kapatid. It is a dot, a speck, minutiae in the great grand story of your law school journey. And as you exhale, envision yourself passing your exam, passing the bar exam, taking the oath and what you'll be wearing on your roll signing. Now, you are ready to look at the problem. The third step is to read the last sentence, then the second to the last sentence, and then the two sentences together. If what you see at the end of the problem are phrases like explain briefly or discuss fully, feel free to include these with the last sentence. We do this, kapatid, in order for us to zero in on the problem. We can only be responsive if we know exactly what is being asked. We skip ahead to the last sentence because this is where the question is usually found. Remember, we can only be responsive if we know exactly what is being asked. Let's look at the last sentence of the problem. What crime, if any, was committed by Madam X? Explain briefly. Let's read the second to the last sentence of the problem for more clues. Zia consented because she needed the money. When the ideas of consent and money are involved, our minds should automatically gravitate towards the concept of price, reward, promise as an aggravating circumstance or qualifying circumstance. Pwedeng-pwede rin naman kapatid na ang crime na tinutukoy dito ay may kinalaman sa abuse or more specifically, prostitution. The fourth step is for us to identify what is being asked in this problem. This is your guiding star. Ito at ito lang talaga ang maaari nating mabalikan kung sakaling tayo ay nalunod na sa mga facts at arguments ng ating examiner. What is being asked in this problem? Here, the examiner is asking us to identify whether or not Madam X committed a crime. Assuming that there is a crime, we are being asked to identify what crime and then we are supposed to explain why we think that crime was committed. The next step is for us to identify the rule, concept, provision, or doctrine that is being asked in the problem. The master key to being hyper-responsive is by identifying the exact rule, provision, concept, or doctrine upon which the examiner has built the problem. If we can reverse engineer how the problem was drafted in the first place, then it gives us the fighting chance to give the precise answer that the examiner is looking for. Dito sa problem na ito kapatid, ano kaya ang sinusubukan sa atin ng ating examiner? What is the rule, concept, provision, or doctrine that is being tested in this problem? If what is being tested is still unclear to you based only on the last two sentences, then feel free to come back to this after the next step. Here, what is being tested is our understanding of crimes involving money and consent. What is probably being tested here is our understanding of the exploitation of minors, prostitution, or any other act involving sexual favors in exchange of money. Again, if the last two sentences of the problem do not clearly spell out the rule, concept, provision, or doctrine that is being tested, then we have to keep an open mind for our answer. The next step now, kapatid, is for us to read the problem from start to finish. We will look for bits and pieces, anything really, that will help us answer the question. We will go over the problem line by line and look for clues that might help us give to the examiner the answer he or she wants. If you see an actor, mark it. If you see the actor's action, mark it. If you think something might be relevant, then mark it. All others we can safely ignore as noise. I hope I'm still making sense so far. Let's begin reading the problem from start to finish. Madam X with the promise of money and without the use of force, intimidation or threat, enticed Zia, a 15-year-old, to engage in oral sex by allowing Madam X to lick Zia's vagina. Zia consented because she needed the money. What crime, if any, was committed by Madam X? Explain briefly. In the first line of the problem, the examiner introduces us to Madam X. She is our actor and her first action is that she enticed Zia, another actor, to engage in oral sex. This act, however, was committed through the promise of money. Promise lang ha at wala pang naging bayaran. This was also done without force, intimidation, or threats. Zia here is a minor of 15 years of age. The examiner continues to give us a graphic description which, if read aloud, would certainly make YouTube ban this episode. Finally, the examiner tells us that Zia agreed to the act dahil siya ay nangangailangan. In the next paragraph, the examiner is asking us to determine what crime, if any, was committed by Madam X. After marking our paragraph, it should look like this. Knowing what you now know about the problem, please pause this video and type up your answers in the comment section. This is the only way for me to gauge your answers and I will try to respond as best as I can. Libre dito ang magkamali, kapatid. Hindi mo ito ikakabagsak dahil hindi mo ako professor at hindi rin kita estudyante. Huwag kang matatakot na magkakamali dito, kapatid, kung ikakatama mo naman sa iyong quiz at midterms o maging iyong bar exam. This problem is a good illustration of the technique called gaslighting. Gaslighting is the process of withholding information from the test taker in order to sow self-doubts and to a certain extent confusion. In gaslighting, the examiner writes a relatively short problem with very few details. There is not much to hold on and the student is left clutching straws in order to write a cohesive and comprehensive argument. In gaslighting, the goal of the examiner is to make us overthink our own answers. The problem is usually very short, contains bits and pieces that are just enough to make us think of a correct answer, but not enough to make a solid and confident conclusion. Parang kasalanan mo pa na kulang ang nakasulat, pero hindi mo naman pwedeng sabihin walang tamang sagot dito. Kung magdadagdag ka naman ng facts, kapatid, ay maaaring lumayo ka naman sa tanong at baka sasagutin mo ang iyong tanong at hindi kung ano man ang itinatanong ng examiner. In this problem, we have Madam X who is in all probability guilty of the crime of child abuse. Malinaw, kapatid. However, the examiner introduces several wrinkles into the problem. The first one is that the oral sex happened without the use of force, intimidation, or threats against Zia. The second one is that Zia actually consented to the deed because Madam X promised to give her money. These two statements may effectively eliminate the charge of sexual assault under Article 266A paragraph 2 of the revised penal code. Ito lang sana ang shoot dahil parehas silang babae. What appears to be a more viable solution is to simply charge Madam X under Republic Act number 7610. This special law covers a wide range of abuses committed against children. Section 5 of the special law even defines for us these acts. Kung ito ang iyong solusyon, kapatid, ay hindi ka naman magiging responsive dahil hindi naman ito ang tamang crime. However, in People versus Salvador Tulagan, the Supreme Court, speaking through Justice Peralta, finally settles the proper nomenclature of the offenses against minors. The decision includes a table of the correct chargeable offense based on two variables, the crime committed and the age of the victim at the time of the commission of the crime. I encourage you, kapatid, to read through this decision and copy the table on your notes as an easy reference. I will be leaving a link to that in the description box below. For our problem, we know that the crime committed was sexual assault. Hiwalay na crime, kapatid, ang rape by carnal knowledge at sexual assault. Walang rape by sexual assault dahil ito daw ay misnomer. Ayon sa isang desisyon ni Justice Leonen, rape is rape. It is forced or coerced sexual intercourse without the consent of another person. It is always committed by a man against a woman because that is the precise language of Article 266A1 of the Revised Penal Code. Sexual assault, on the other hand, is a gender-free crime. It is committed by any person who, lalaki man o babae, under any of the circumstances mentioned in Article 266A paragraph 1, shall commit an act of sexual assault by inserting his penis into another person's mouth or anal orifice or any instrument or object into the genital or anal orifice of another person. Dito sa ating problem, pasok sa konsepto ng object ang anumang bahagi ng ating katawan maliban sa ari ng lalaki. Dahil ginamit ng examiner ang phrase na oral sex, hindi na natin ito pwedeng tawaging acts of lasciviousness lang. It necessarily includes the insertion of an object which in our problem would be the tongue of Madam X. The degree of penetration again is immaterial. Sexual assault is consummated upon the touching of the object with the victim's pudendum. If we look at the table given to us by the Supreme Court in the case of People versus Tulagan, we will know that the crime committed here is sexual assault against children exploited in prostitution or other sexual abuse. However, Republic Act number 11648 effectively amended the ages stated in Republic Act 7610. Section 5B as amended would now read as those who commit the act of sexual intercourse or lascivious conduct with a child exploited in prostitution or subjected to other sexual abuse, provided that when the victim is under 16 years of age, the perpetrators shall be prosecuted under Article 335 paragraph 2 for rape and Article 336 of Act number 3815 as amended, otherwise known as the Revised Penal Code, for rape or lascivious conduct, as the case may be, provided that the penalty for lascivious conduct when the victim is under 16 years of age shall be reclusion perpetua in its medium period. In this problem, Zia was 15 years of age at the time she had oral sex with Madam X. The proviso will now be made to apply. Articles 335 and 336 contain references to rape before it was designated as a crime against persons. I know this sounds convoluted and complicated, kapatid, but when we put all of this together, the proper charge would be Article 266A, Paragraph 2 of the Revised Penal Code in relation to Section 5B of Republic Act number 7610. We begin our suggested answer with Madam X committed the crime of sexual assault under Article 266A, Paragraph 2 of the Revised Penal Code in relation to Section 5B under Republic Act number 7610. Notice, kapatid, that I have used the precise language of the law. The law demands precision in everything we do. However, I have taken the liberty of not writing the entirety of the provision. Doon lang tayo sa relevant, mahalaga, at magagamit natin sa susunod na paragraph. Our next line is our most important paragraph. Next, we need to write our legal basis. The law does not require that you cite the entire provision of the law. All that matters is you write the most relevant portions of the law. Under our criminal laws, the crime of sexual assault is committed by any person who shall insert any object into the genital or anal orifice of another without the latter's consent. When the crime is committed against a child below 16 years of age through the coercion or influence of an adult, there is exploitation or sexual abuse. Notice, kapatid, that I have used the precise language of the law. The law demands precision in everything we do. However, I have taken the liberty of not writing the entirety of the provision. Doon lang tayo sa relevant, mahalaga, at magagamit natin sa susunod na paragraph. Our next line is our most important paragraph, our arguments. This is where you have to argue. Ilaban mo yan, kapatid. You cannot parrot back to the examiner the facts that he or she has written down. Wala siyang paki dito, kapatid, dahil siya ang nagsulat ng problem. Malamang sa malamang ay alam din naman niya ang kwento nito. In this next line, we have to tell the examiner why we have taken this position and why we have chosen this legal basis. We have to give back to the examiner what he or she needs. It's our chance to say, "Ha, I see what you did there." We do this by arguing why we are correct. In effect, we need to sell to the examiner why we are correct. You can land at the correct answer, kapatid, pero kung hindi mo naman ito maibebenta, kung hindi mo naman makukumbinsi ang examiner na tama ka, ay wala ka na ring pinagkaiba sa ilang libong sagot na dadaan lang sa kanyang mga mata. We stand out by first being hyper-responsive to the problem, and second, through our eloquence. This begins by laying down the strongest argument. What is our strongest argument here? The strongest argument here must be anchored on the nature of the act committed by Madam X. It is no longer an act of lasciviousness, but one of sexual assault. We have to follow this up with Zia's age because it is determinative of the precise charge as applied in the table under People versus Tulagan and the amendments introduced by Republic Act number 116548. Now, how do we say all of this in the simplest, most concise manner possible? In this problem, Madam X is liable for the crime of sexual assault because she had oral sex with Zia, who was then only 15 years old. Zia is deemed to be an exploited child because she consented to the deed on the promise of money. Notice, kapatid, that we began our suggested answer with "in this problem." Masakit sa mata ang mabasa ang "in the case at bar" dahil wala naman tayo sa korte at ito ay isang academic exercise. Hindi mo yun ikinakatalino, kapatid. Pwedeng-pwede na rin kami sa "here, comma" dahil madali lang itong dot-dotin sa iyong keyboard. I hope I'm still making sense so far. Next, you need to phrase your answer in the form of an argument. You are in law school because you are hoping that someday, one day, you will be a lawyer. At a certain point in your life, kapatid, you will be arguing for a living. Hindi ko naman sinasabi na maging palaaway ka, kapatid. Arguing means convincing your professor, your examiner, or the courts on the merits of your position. Arguing means selling your position and convincing your professor of the correctness of your answer. In your third paragraph, you need to argue. Hindi ka pwedeng umulit lang ng facts. Wala ka nang magiging kaibahan sa ilang libong booklet o answer sheet na dadaan lang sa mata ng mga examiner. Dapat kapag binasa ng professor mo ang sagot mo, masasabi niya na magiging abogada ang batang are. With our conclusion, the suggested answer should look like this. Madam X committed the crime of sexual assault under Article 266A, Paragraph 2 of the Revised Penal Code in relation to Section 5B under Republic Act number 7610. Under our criminal laws, the crime of sexual assault is committed by any person who shall insert any object into the genital or anal orifice of another without the latter's consent. When the crime is committed against a child below 16 years of age through the coercion or influence of an adult, there is exploitation or sexual abuse. In this problem, Madam X is liable for the crime of sexual assault because she had oral. The worst mistake you can make in a conclusion is to simply repeat your opening statement. This would be a waste of your examiners or professors' precious time and attention. Marami ring hindi na lang nagsusulat ng conclusion dahil ayaw na lang nilang umulit lang ng first sentence. When you don't know what to write, Focus on the fruits, effects, and results. Assuming that your answer is correct. Ano kaya ngayon? Salamat kapatid at sinamahan mo ako sa ilang minuto na tayo ay nagsagot ng isang bar exam problem. I will be doing my best to respond to all of your answers in the comments and give you timely feedback. Sana at kahit papano ay may natutunan ka. The means and methods I've discussed here are all contained in our digital workbook 8, 101 practice problems for lost law students and bar takers. Here you will be tasked with answering about 105 bar problems spread out in various bar subjects. All of the answers here are broken down, explained, and discussed in much greater detail than what we have done here. You will also learn about how examiners draft their problems, where questions come from, and how to predict with a reasonable degree of accuracy the problems that might come out in your midterm and final exams. In this workbook, I've also discussed the common tactics that professors use to confuse law students and baristas. At ano ang pwedeng pangontra sa mga tactics nila? Narito rin ang mga typical na mali ng mga law students sa kanilang mga sagot at kung paano natin ito gagamutin. Follow along the journey as we help you take your answers from miserable to elegante. Grab your copy of 8, 101 practice problems for lost law students and bar takers through the links in the description box below. If you would like to see more episodes on how to answer law school exams and bar problems, please let me know by typing yes in the comments down below. Thank you so much for watching. Like and share this video for good law school karma, and I will see you next Friday.